Hello, I'm Lori Morgan, and I'm a judge in the Allen Superior Court Family Relations Division. A little while ago, the magistrates and I, along with representatives of the Department of Child Services, our Office of Guardian Ad Litem Court-Appointed Special Advocate, and service providers who work in our court, started thinking about you and how much you matter to all of us. We wanted to find a way to give you an opportunity to appear in court and have your voices heard. We felt that it was important to put a policy or rule in place that allows you to come to court and be involved in court hearings that are about you and your family. Our court has now put together a policy for children who are 14 years of age or older and have cases in our court so that we can make sure that your voices are heard. The policy allows children who are 14 years of age or older to come to review, permanency, or detention hearings if they want to do so, and if the professionals who are working with them believe that it's appropriate for them to do so. About 30 days before a scheduled review or permanency hearing, or as soon as is possible before a detention hearing, your case manager and/or guardian ad litem or court-appointed special advocate will fill out a form that will let us know whether you want to appear in court. They will also be checking with people who are working with you, like your therapist, and will decide whether it's okay for you to appear in court. If you want to appear in court and there aren't concerns about you doing so, you will be allowed to come to the scheduled court hearing. When you come to court for your hearing, you may attend all of it or just the first part of it, depending on how challenging the hearing is. If you attend the first part of the hearing and are excused from the rest of the hearing, that means that after you speak with me or one of the magistrates, you may leave the courtroom and go back to school or to the home where you're currently living. Or you may sit outside the courtroom until the hearing is over, whatever is best for you. If you're not comfortable attending the hearing, or if your case manager, guardian ad litem, or court-appointed special advocate, or your therapist feels that it's not in your best interest to attend the hearing, you may fill out a youth report form that tells the court how you're doing and whether you need anything. If you don't want to fill out a youth report form, you can write a letter to the judicial officer who's hearing your case. If you fill out the youth report form or write a letter to the court, our rules require that we must share it with all parties involved in your case, which means that your parents, the Department of Child Services, the guardian ad litem, court-appointed special advocate, all must be allowed to see it. Now, I want to tell you about what will happen when you do come to court for a review, permanency, or detention hearing. First, you'll check in room 208, and you'll meet our court services representatives. They will take your names and put them in the computer so that we know that you're here for your hearing. Then we'll tell you where you'll sit until your case goes into court. Your case will be assigned to one of 4 courtrooms: room 212, room 204, room 205, or room 207. I'm the judge who oversees the Chins Division at the courthouse, and my name is Judge Lori Morgan. There are 2 magistrates in our division, Magistrate Sherry Hartzler and Magistrate Beth Weber. When your case goes into one of our courtrooms, everyone will find a seat, and the Department of Child Services case manager will give the judicial officer a piece of paper that lets the judicial officer know who's there for the court hearing. The judicial officer's court reporter will turn on the recorder, and the judicial officer will start the hearing by saying who's at the hearing that day and what the hearing is for. Then the Department of Child Services attorney will be asked to make statements about the reason for the hearing. The court will then turn to your guardian ad litem or court-appointed special advocate for comments, and after he or she has made comments, you'll have a chance to speak to the court. After you speak, if you choose to do so, the court will decide whether to excuse you from the hearing or let you stay for the rest of the hearing. If you're allowed to stay for the whole hearing, you'll be in the courtroom until the hearing is over unless the judicial officer decides otherwise. If you're excused from the hearing, you're free to leave the courthouse with your caregiver, or you can wait outside the courtroom until the hearing is over. At the end of each hearing, the judicial officer will let everyone know when the next hearing is, which is usually about 6 months from the current hearing. We'll repeat this process of determining whether it's appropriate for you to attend your Chins hearing before each scheduled review, permanency, and detention hearing. If you have any questions about the process, please feel free to ask your DCS case manager or guardian ad litem or court-appointed special advocate. All of us involved in Chins cases care about children and families and very much want to hear from you and see you in court. You're important to us. Your voice matters. We look forward to seeing you in court.